Hi everyone, welcome to Asala's Classroom Talks, where we mentor future lawyers, we foster critical thinking, and we simplify the law for law students, for lawyers, and the general public. Today we are privileged to have Beth Leon, who is going to be our guest for tonight, and we will be discussing the topic uh, race, culture, mental illness in the ICC's Ongwen judgment, biases, and blind spots. This is based on a book that has been authored by Beth. So welcome, Beth, and please introduce yourself to the audience.
Thank you, Professor Asala. I'm very pleased to be here, and I want to thank you for this opportunity. And also, I want to thank Peter for all of his technical assistance so far for this program. I'm a defense attorney. I now practice at the International Criminal Court. I practiced at the Rwanda Tribunal, the ICTR in Arusha. I did 3 cases there. And prior to that, I was trained in New York City as a legal aid attorney. I did trial work and also criminal appeals. I got to that place of law as a second career. I started out as a labor organizer. I came out of the political movements in the US in the 1960s. I was active in the anti-war movement, in those days, Vietnam and Cambodia. I was active and supportive of the civil rights movement, the women's movement. That's the context in which I formed my political views. So I got to the law already with a worldview kind of formed. I was interested in criminal defense because I basically thought about it like organizing workers into a trade union, which I had done. You talk to juries, and I wanted to talk to juries. Little did I know that the way things work in criminal defense and legal aid in New York City, it's very hard to get, quote, jury trials. That's another subject. There are plea bargains galore, especially for lower level misdemeanors, even lower level felonies. And sometimes, given the backlog of cases, it would take longer for a client to go through a trial and possibly face conviction, or maybe an acquittal, but possibly face conviction, than it would take to enter a plea for a lesser charge in less time. So there are all these kind of economic factors, so to speak, involved in the law. I desperately wanted to get out of legal aid. Legal aid is essentially a factory processing operation, probably in most countries, but definitely in the US. We, as legal aid attorneys, had dockets of close to 100 people. Now, not all of those cases are trial cases, but you have to show up and hope your client shows up so that he or she doesn't get a warrant. But bottom line is, there's very little time and even less resources to focus on any one case from beginning to end, and particularly the cases that needed the kinds of attention because of who the client was or what the situation was. So I was happy to start a career in international law. I'm also part of an international lawyers group, an NGO, International Association of Democratic Lawyers, where I do human rights work, etc., at the UN in New York. But I wanted to combine all of this, and so the ICC, after the ICTR, was a logical place for me to do this.
Thank you, Beth, for that great introduction. Perhaps if you may just share with us a little bit, what first drew you to practice before the International Criminal Court, particularly on the defense side?
Okay, for me, it was never a question. It never even occurred to me to be a prosecutor. And I say that honestly. That was a political decision on my part. It was my observations and experiences in the US of the role of the state, particularly in the 60s and 70s and on, and its role in the rest of the world, good old US imperialism. And I had no interest in being, defending the state, which is what I thought that, every single prosecutor had to do. Now, in reality, that's not probably true. But I was, 18, I was college, 18, 19, 20, 21, and these were my kind of unrefined views. So as I said, it didn't occur to me. I didn't like what the state was doing. I didn't like the involvement of the FBI in our country, its attacks and assassinations of Black leaders, et cetera, during the 60s. So all of this kind of influenced me. So as I said, it never occurred to me to represent the state and those who had power and means. And I looked at legal aid as a way to represent people who did not have access to justice, who did not access to justice based on race or gender, disability, whatever it was. And so as I said, it was never even something I thought about.
Mm-hmm. Mm-hmm. What does it mean to you, Beth, at a personal level and also at a professional level, to defend individuals accused of some of the gravest crimes ever known to humanity?
Well, let me start out this way. Defense attorneys, no matter where you are, whether the ICC or, whether you're in, I would think in Nairobi or you're in New York City, or it doesn't matter where you are, defense attorneys are generally regarded as pariahs. I would be surprised to know if there were instances where that was not true. The reason is, I think, that there's a sense in the courts and also among the public that defense attorneys are basically equated with their clients. There's a certain kind of transference goes on. You feel it in court. You're standing next to your client in court, and you can feel the judge is transferring whatever he or she is charged with to you, right? And at the same time, your clients look at you and they say, we don't want legal aid, we want an attorney. So you're losing either way, right? But the bottom line, this is transference. And in this transference, people forget, including especially lawyers and colleagues, that there's a presumption of innocence under most constitutions, in most countries, in most legal systems, certainly in international documents and covenants, etc. So I found, though, that once I started working at the international courts, I was shocked at few even attorneys who came up to me and said to me, how can you defend X, right? Because these attorneys who I thought knew better, right, were saying these persons who have alleged to commit X do not have the right to a fair trial. Our focus is obviously on fair trial and process. We weren't there. The defense attorney is never at the place where the allegations occurred. It doesn't matter what the crime is. And if he or she were there, that person is conflicted out and shouldn't be representing the client. But bottom line is that you were not there, you don't know what happened, and you find out that there's more to the cases, especially the international criminal cases. These are political cases. At the International Criminal Court, the ICTR for Rwanda, the former Yugoslavia Tribunal, ICTY, a special court for Sierra Leone, etc. These are political cases. And what's at stake are two things. There's a legal case, based on the statute of the court, right? Any proof and evidence and trial procedures, etc. But what's also going on is that there's a political narrative, essentially, which comes generally from the prosecution's office and is evident in the confirmation of charges decisions at the ICC, or which is equivalent to an indictment in other systems. A number of scholars of international law and practice have talked about how the tribunals are less about culpability sometimes and more about the historical narrative. Writing, a colleague, uh, um, Wilson, Professor Wilson, wrote a book called Writing History in International Criminal Tribunals, right? A former prosecutor at the ICTY pointed out, and I'm quoting him from a lecture, the struggle for the interpretation of historical events through the trial record might be as important in the long run as a determination of guilt or innocence of the individuals tried. All this to say is there's a courtroom, but there's this whole political context of what is happening. And you have to figure out how to try your case legally, but also how to be aware of this political context and how it affects your case.
Thank you so much, Beth. You did mention about the presumption of innocence of the accused person, and you're also relating it to the political context. One has to appreciate the political context within which the trial is happening. But ordinarily, you notice that this context, it comes with the overwhelming public and media perception, that an accused person is guilty. How do you, as a defense lawyer, ensure a balance between the presumption of innocence, as well as the overwhelming public perception, as well as media perception of the guilty nature of an accused person?
I'm not sure in many ways that I, as a defense lawyer, have control over a balance. I think it begins to relate to the issue of what does a defense lawyer do, right?
Mhm.
And I think and what are the tasks of a defense lawyer? I mean, essentially, the defense lawyer has to figure out how to tell the client's story one way or another through the trial. But as importantly, and part of that is bringing out the truths of the situation. The ICC cases deal with either conflict situations or pre-conflict situations or post-conflict situations, right? The titles of the cases of the ICC, they don't start with the defendant's name. They start, for example, in Ongwen, the situation in Uganda, right? And I think that's pretty important in terms of what should be done. So I think that the role of the defense lawyer is to fight for that truth in many ways. I think that part of that is fighting for a fair process, what we call leveling the playing field. The situation of defense, it doesn't matter where, but certainly the international courts and tribunals that I've seen, is there's no level playing field between the prosecution and the defense. What does this mean? You don't have the same amount of resources. Your client doesn't have access to translation of key documents with which saying what he's charged with. You don't have the same number of slots on your teams. You can go into an ICC courtroom. I mean, I look across and I think, my God, where did all these people come from, right? The defense has X number of people based on a legal aid scheme, which is, as everyone knows, legal aid is always reduced, right? And then has to rely on volunteer interns and lawyers. But the prosecution has all sorts of things. They have lawyers, they have assistants, they have experts on different kinds of crimes. They have experts without portfolios that are there to advise the chief prosecutor. There is never any equality, nor is there transparency. And I mean, I can't tell you how many years I've tried to find out, what is the defense budget versus what is the prosecution budget. So I think that's really important. we face that problem, and I think that there's, as I said, there's no equality from the beginning. There's a second aspect to that, which is that in terms of getting documents from states, for example, there just simply isn't, we don't have the same kind of access to get the necessary disclosure from a state the prosecution does. And we always end up getting late disclosure. You know, we got 3,000 pages in my ICTR case. You know, it was like, I don't know, a year and a half after the prosecution had finished its case. It was for 4 co-defendants. You had to go through it by hand, literally, on the computer to see what pertained to whom. We finally won a judgment that we were prejudiced by this information, but the prosecution was holding on to documents, 10 years, 15 years. This is not unusual. I mean, there are a number of instances in the Ongwen case where this has happened because the prosecution is under a duty to disclose exculpatory, which means evidence that could show that your client is innocent, right? Exculpatory evidence as soon as possible, or evidence that would affect the credibility of its witnesses, right? According to the ICC rules. It just doesn't happen. So you end up fighting for, as I said before, trying to level the playing. That's basically what you try to do. And I think that that's, we talk about it in terms of, quote, equality of arms. There is no equality of arms, meaning there is no equality of resources, experts, etc., available to the defense.
So in the presence of this imbalance, the absence of a level playing ground, and given your experience as a defense lawyer, would you say that the rights of an accused person are adequately safeguarded under the Rome Statute of the ICC?
Oh, absolutely not. I have no question. I mean, there is absolutely nothing to indicate to me that they are adequately that they are adequate. And I can give a few examples. Let me just looking one moment. One example is that when my client, Mr. Ongwen, was sentenced for his convictions, he was being sentenced on a judgment which was 1,077 pages, which had not been translated into the language he speaks and understands, right? According to the rights of the accused under Article 67, I'm just going to read it. The accused should be informed promptly and in detail of the nature, cause, and content of the charge in a language that the accused fully understands and speaks. Now, this is talking about being informed about the charges, not the sentencing. But we should also say that there were so many defects in the indictment, so many places that were not detailed, that were not specific, that were vague. In other words, did not provide the kind of information where an accused person could sort of take this information with his or her lawyer and figure out, how do we deal with this? Should we investigate? What should be our defense, etc. So none of this happened. So I think that we start, or I'm saying I start from a premise that the defense has to defend the rights of the accused. What in the case of the ICC, Article 67, you move on from there. So you spend a lot of your time defending these rights. So I think that's the problem. It's not a given, right? It's not a given. You walk into a courtroom and the judges will respect your rights, the prosecution will respect your rights. I mean, it doesn't work that way. The victims, who are also an entity on the prosecution side, that they will respect your rights. It just doesn't happen this way.
Okay, and Beth, could you please walk us through step by step in a typical scenario? What are the stages do you go through to prepare for a defense before the ICC case?
Sure. I think that first of all, I want to thank Advocate Ongwen, who was speaking to you last week, right? Because his lesson is prepare, 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 and I certainly agree. Um, I mean, I can't, before I get into the steps, there's certain things taking off on what he said I want to emphasize. The defense has to know your judges, know who the judge in your pretrial chambers, judges are, your trial chamber, the appeal, know where they come from, not just their systems, what they do, how they think, what they've ruled on, right? If they've ruled on any prior cases, know your judges. You have to know the law not only of the charged crimes at the ICC, but modes of liability, which are very detailed, and that's a whole other lecture. But you have to know the law on this, and it's important to know what's happened in other cases. Now, what happens in one trial chamber doesn't determine what your trial chamber will do, but it gives you some idea. And you have to look to see how did the judges in another case rule on something, all right? The rules, you have to know the rules. I mean, you're thrown out if you're late. I mean, late with a pleading. You can't do that. I mean, you can't do that in any court, but know what the rules are, know specifically what the rules are, and you'll find yourself fighting for, extensions of time and word limits and all sorts of things. But you need to know the rules. And lastly, perhaps most importantly, know your client. You have to interview your client time and time again. All right. I'm not, I don't have a position about truth telling in clients per se in general. But let me simply say that you will be told something by a client, and this was true legal aid, this is true for private clients, it doesn't matter who, and it's your job as defense counsel to verify and investigate. The other thing is you have to develop, you have to know the case against your client, right? Now, this is a big deal. I mean, there were 104 pages. There were 70 charges, 6 to 8 modes of liability against Mr. Ongwen. That's a lot of material, all right? But you have to know the charges to begin to understand what could be a defense. And it's a give and take process. The process is dialectical. The more you read the charges, you have to think about them. You look at what your investigators are saying from the ground. You listen to your client. You meet with your team. It all goes into I don't know, you have a discussion about all these things in one basket in many ways, and you go back and forth. You play devil's advocate on your team. But these are the kinds of things you have to do. I think also you have to be ready for the long haul. These cases take forever. Well, not forever, but years. We're not talking about a legal aid case that may last a very long time, but usually it's a year or 2 or 3, maybe it's 10 if it's, but we're talking years. In 2005, the first arrest warrant in the Ongwen case was issued. Ongwen was named with 4 other people, including Joseph Stoney. The case did not reach a pre-trial chamber until 2015. Why? Because Mr. Ongwen turned himself in, right, in 2014. So, these things are important. And then strategy and tactics. As I said, you have to really work on strategy and tactics because you can't be caught kind of changing midstream. You'll definitely lose. There's no question. You have to be consistent. And lastly, I would emphasize 2 other things. Again, the importance of the teamwork, particularly the team on the ground, and connections between the investigators and counsel, etc. And the last thing I would emphasize is something that every appeals lawyer knows, which is preservation. What I mean by that is that through each stage, there will be objections in respect to fair trial violations, right? you didn't get something, something is vague, something is defective, all these problems. Information is withheld, it goes on and on. You must preserve them from the very first audience with the court so that when it comes time for the appeal, 5, 6, 7 years later, you have preserved the issue, which means the issue is on the record clearly as an objection so that you can then litigate it in front of the appeals chamber. I've read countless transcripts from the states, I did appeals work from international ICC, ICTR, and you'd be surprised at how many attorneys do not clearly put on the record, I object to X because it violates Y, and you cite the rule or the statute or case law, whatever it is. So that's something I would say. And in terms of the stages, you can go through pretrial, trial, appeal. I mean, there are different tasks at each stage. That's another discussion. But I think that what I'm trying to talk about here are some of the principles of what should guide you through each of these stages.
Yeah, thank you very much, Beth. And I know most of our audience are students and some of them are lawyers, and they desire to one day become a defense lawyer before the ICC. So how does one become a defense lawyer? What do they need to know?
All right. The advice I would give younger members of my team who were either sometimes lawyers or LLM graduates, particularly from both European and sometimes African universities, the advice I would give would be try a case in your own country. Now, people would look at me like I was crazy, right? These individuals had, through their sweat and determination, they had a way to work on an international case as a young lawyer, as an intern, as a volunteer, right? They may have been admitted in their own country, but I was somewhat old-fashioned. I really think if you can try a case in your home jurisdiction, it helps you to no end. It's not a prerequisite, but it really helps you. But I noticed that people have come through, lawyers with LLMs have come through the UN system. So there's another kind of gateway, which is you get an LLM. You may not have done in French countries, it's called stage. In other countries, it's an internship with a law firm, or pupillage, right? You may not have done that, but somehow you get yourself to the ICC in a voluntary position. You work your way through a team. So, I mean, I don't know what's best. Technically, you can go to the website. There's a list for defense counsel and also for victims counsel. Actually, it's the same list. You can represent both. There are rules as to what you have to do. You fill out a huge application. It's the UN, it's bureaucratic. You have to provide certain documentation. It's all there. So once I advise to young attorneys, get yourself on the list however you can, right? But I also advise, if you're really intent on working international judicial fora like the ICC, if you have any way you can do it, try to get yourself in some capacity on a team, because that's how you get to know people. And eventually, if you're lucky enough to get a case, to get off the list, right? Because there are hundreds of people on the list. All the people on the list don't have cases. There aren't that many cases at the ICC. It's impossible. So in my own case, it was word of mouth. I mean, I spent years trying to get on a case. I worked on a case pro bono while I was at Legal Aid, ICTR, finally got on it. I did 3 cases there. There was a hiatus, then got on to an ICC case, the Arito Article 70 case, and then the Ongwen case. And I work now on my ICC cases with Chief Charles Fafu from Cameroon, who's excellent, who I met at the ICTR. But you have to make the personal connections also. But you just have to, grin and bear it. You have to do the paperwork, do the legwork, fill out all the UN stuff first. So that's the only advice I would give.
Okay, thank you for that. You are the author of the book titled Race, Culture, and Mental Illness in the ICC Ongwen Judgment, Biases and Blind Spots. What was unique about the Ongwen case that compelled you to write this book, Deb?
Okay. Let me, I think, let me go to the slides at this point also, because I have. Okay, Peter, I may need your help. Can I go to share? Can I get a share slide? Okay. Share. All right, it's not. And I'm trying to go to my slideshow. Okay. And I go to. Okay, this is a picture of the book that was it was on the very beginning. I'm not really sure that it's so much a question of what's unique about Ongwen, but I would say what was so egregious about Ongwen, almost. I mean, in many ways. The Ongwen case, as I was working on it as a counselor, I did a lot of work on the mental illness defense. The judgment convicting him and the judgment where the court said he did not suffer any mental illness, which would have been grounds for excluding criminal responsibility. I mean, I can't say it shocked me, but I felt like it really was a slap in the face to child soldiers every place, including Mr. Ongwen, to people who have mental illness, to people who are disabled, and to somehow people who come from societies that do not represent the Western cultural ethos of the ICC, right? And I began to look at this, and I began to think about it in terms of what was going on here. And I began to look at the case. I began to look at the judgment. And I began to start thinking, as I had during trial, about what were the biases and what were the blind spots in this judgment, particularly the issues of racism in terms of a white blind spot, and a certain kind of culturalism which rejected Mr. Ongwen's Acholi culture. So I think that I was motivated to write the book because I was so aghast at what had been going on. Now, we all know that there are critiques out there by persons more expert than I, on the structural racism of the court. There's no question in my mind that the ICC, until last few years, has targeted only persons of African descent, persons from the African continent. These persons are the only persons in the dock. End of story, right? In 22 or 23, there were the arrest warrants issued for Putin and Lvova Belova, the woman who was involved in the allegations of unlawfully transporting and transferring children from Ukraine to Russia, and then of course the arrest warrants against Netanyahu and Gallant for the Israel's crimes of genocide. Well, it wasn't genocide, but crimes starvation, etc., crimes against humanity in Gaza. And I think that up until then, for 22 years, it's what some authors have called criminalizing Blackness. Essentially, persons were criminalized by who they were. So I began to look at some of this in terms of the judgment, because it's not just who the defendants are, what the structures are, who the prosecutors are, etc. It also is this racism and culturalism is reflected in the jurisprudence. And that was the main thing that I was trying to bring out in this case.
Oh, interesting. And in your opening chapter, Beth, you make another very strong argument that if Ongwen had been white, yeah, and if the LRA, the Lord Resistance Army, had been a predominantly white cult, the ICC chamber would likely have reached a different conclusion. Why do you think this is a true position?
I think that this is true because essentially, if you take out the white supremacist bias and blind spot of the judges and their analysis, then I believe that Ongwen would have been acquitted, right? I mean, if he were part of a white cult, for example, I believe that the three judges would have handled the evidence, would have looked at him differently, essentially. That's what I think would have happened. And it was just, at first it's just a sense, and it's from talking to people. And then if you look at the jurisprudence, you sort of see it, which is what I try to do in the book, right? There's a sense of, we had two Ugandan defense experts, psychiatrists, who were Black Ugandans, right? And the trial chamber never found even reasonable doubt in the prosecution's case, which was Mr. Ongwen was not mentally ill and is fully culpable for the crimes. Mr. Ongwen, abducted at 8, was by the LRA, the prosecution said was not under duress, right? So I think that it's a factor. It's not always a factor you can put your finger on, but it's definitely there. And I think that, in a few slides, I'll talk about some examples, but I think that that's why I came to that conclusion.
Okay. And you've said before that Ongwen was abducted as a child. Yeah, yet the ICC held that he became a perpetrator when he attained the age of majority, which is 18 years, and this is the threshold required for culpability under the Rome Statute. Which argument you disagree with in your book? Yeah,
Okay.
with your reasoning. Could you please explain your reasoning?
Sure. 1 second. Basically, as you can see from the screen, the Article 26 sets 18 as the age of culpability. Now, the crimes with which Mr. Ongwen was charged and for which he was convicted took place when he was approximately, say, early 20s. It wasn't like he was just a few years above. He was a young adult, a few years above 18. Now our position was that the chamber basically applied this statute rotely. On the one hand, the prosecution, in her opening statement, the chief prosecutor, then Fatou Bensouda, admitted that some people may be sympathetic to Mr. Ongwen, that he was a victim, but he became a perpetrator, right? This concept of victim into perpetrator is tied to this. Somehow the idea that at the age of of 18, he magically becomes a perpetrator, right? After he's been, abducted by the LRA, he's been forced under their discipline to do heinous acts against other abductees, et cetera, et cetera. We also presented defense evidence that being a child soldier never ends. A child soldier doesn't have a mind of his own. He doesn't have a capacity to make judgments between right and wrong. All of this was rejected. And I think that this was our criticism. And I think that that's why I would say that we disagree with Article 26.
Okay. Thank you for the explanation and why you disagree with the threshold provided in the Rome Statute in the Ongwen case. You also relate to the defenses of mental illness and duress, which feature predominantly throughout your book. Maybe just to help us understand, how do these defenses operate in the Rome Statute, and why were they central in the Ongwen case?
Okay. Let me try to get some, I have some slides on this that may be helpful. Let's go back. Okay. In the Rome Statute, there's section Article 31, grounds for excluding criminal responsibility, right? A crime occurs, the person is not responsible for that crime because he or she does not have the mental capacity to appreciate, to understand what is unlawful about the conduct. Does not have the capacity to control his or her conduct. Okay, and I think that that's basically what Article 31 says. There are two parts to this. In our defense, Mr. Ongwen was mentally ill, and secondly, he was acting under duress, which was the control of the situation, the coercive situation was Joseph Kony, right? Who's now in absentia in the dock, so to speak, of the ICC. This case, by the way, was always about Kony in our view. I mean, Mr. Ongwen was an abductee, period, right? He never had the power, the authority, any of that. Kony controlled everything because Kony, who was acted sort of as a median, spiritual median to Ongwen, but to all these people who were greatly affected by spiritualism. Kony abused this religious spiritualism to exercise his control. In terms of this defense, the mental disease part of it, our experts, you can read for yourself, found multiple illnesses, severe depressive illnesses, dissociative disorder, PTSD, etc. And there was a court-appointed expert who also basically agreed with them. And what did the child chamber say? At this paragraph 2580, it says, we don't accept any of this evidence. So that's where we are on that.
And actually, that leads me to my next question, Beth. The child chamber rejected defense expert evidence, citing concerns over methodology and suggesting that, if the method is flawed, then the conclusion is flawed. So in your view, what exactly was faulty in your defense methodology? And, what would you say of the chamber's reasoning in that case? Was it sound?
Okay. Sorry, I'm just trying to get to the right slides. One moment. Okay. Basically, the chamber had a very involved, as you can see, you don't have to read all of this. I can send you the slides, but had a very complex complex framework for its methodology critique. Now, keep in mind, this was the same chamber who accepted our experts, Professor Avuga and Dr. Akena, right? Now, my own position, in the defense position, there was absolutely nothing flawed in the methodology. This is a rather extensive discussion, which we can't go into, but I can point you, if you're interested, to our briefs and some of our pleadings on this. And it's in the book, some of this material and some of the references. But basically, I want to concentrate on, there are 6 things here you can see. I want to concentrate on number 2, which is the failure to apply scientifically validated methods and tools. And number 5, malingering. Okay, let me say what this means. Okay, basically the prosecution position was, the prosecution experts was, you can't believe anything Ongwen told the defense experts or told the court-appointed expert because he lied, right? He was, quote, faking it. He was making things up. He was making up symptoms of all of these mental illnesses, although he had been in the bush all of this time, but nevertheless, the claim was he was making up symptoms. And what the one of the points of criticism from the trial chamber of our experts was that they did not make an assessment of whether Mr. Ongwen was lying or not by using what's called a psychometric test. They simply used their experience and expertise and listened to him and looked at him, right? Listened to what he had to say and said, we don't need to do that. These psychometric tests, which I learned about, are used in many parts of life. They're used in employment, etc. But they're cognitive tests. They have been criticized within the psychiatric profession for being Western-based, requiring that the person being tested have a high level of education, right? And not at all being adjusted to individual cultures, whether cultures in Africa, cultures in Asia. All of the references are in the book. So basically, the chamber is taking this already criticized test and saying, you didn't use it, experts, defense experts, so what you're saying isn't valid. All right, that's the first thing. The second thing that the trial chamber did was they said that the defense didn't consult with laypersons, and they being the chamber put a lot of emphasis on what other abductees saw and observed in Mr. Ongwen. Now, this whole framework is a little bizarre, right? Because abductees were all under very, very strict rules. If they were out of line, they could face death, or their communities could be attacked by the LRA. I mean, we're talking about very, very severe repression. All right. So in other words, but the chamber is saying that the abductees, did they notice anything wrong with Mr. Ongwen, right? And this is what they've emphasized in their judgment. And I call it the layperson criterion, right? They believe that the abductee layperson could somehow see symptoms in Mr. Ongwen of mental illness. And because no layperson reported symptoms, Mr. Ongwen, it doesn't have mental illness. That was the conclusion. Now, what this left out was that what I see, what you may see, what anyone sees as normal behavior is culture bound. It doesn't matter where you are, where you live. what your religious beliefs are, if any. It doesn't matter, okay? But in this case, in northern Uganda, there was testimony from our expert that other abductees would look at Mr. Ongwen and they wouldn't think mental illness. They would think he's possessed by the spirit. And this was kind of a normal in terms of how these people understood how spirits operated, what was normal, what wasn't, what does possession look like. And the trial chamber basically disregarded all of this. They also disregarded the fact that as our experts said, in Uganda and in other parts of the continent, mental illness is not necessarily discussed as, quote, mental illness, right? People tend to somatize. They tend to express, mental distress or illness in physical forms. None of this was considered by the trial chamber. And lastly, as one of our experts testified, and this is detailed in the book, many of those tests that I just talked about earlier, these psychometric tests, they have questions like the depression test had a question saying, are you feeling blue? Well, there's no word for feeling blue in many African languages. So how is a person supposed to answer, right? So you have all these factors that add up to more than an insensitivity to what was going on with Mr. Ongwen and what people around him saw, right? They add up to a kind of dehumanization, a kind of racism in my view, right? They said they didn't see Mr. Ongwen for who he was. He was invisible to them, right? They didn't see his culture. They didn't see where he came from. And at the same time, they used well, you can read for yourself. Look at the language they use to describe some of these issues that have that are culturally based, right? They say, for example, I'm looking at slide 12, paragraph 2463, the absence of the word blues in many African languages. This is trivial and has no serious link to what we're considering, right? Later, they say the possibility that witnesses may regard symptoms of mental disorders as spirit possession is immaterial. Now, what kind of a trial chamber uses words like trivial, right, and immaterial to talk about evidence, whether they disagree with it or not, but evidence that is culturally based? I mean, you can answer the questions for yourself. So that's how I would talk a little bit about the methodology issue here. As I said, everything is a longer discussion because it was such a long case and it's so involved. But I would urge you to take a look at the book, take a look at the links, and you can get much more information and a better sense of this.
Thank you, Beth. Drawing on your analysis in chapter 2 on what went wrong in the Ongwen case, what reforms would you propose to better safeguard the fair trial guarantees of an accused person in the ICC?
Okay. All right. I think that first of all, you can take a look at the book. Both chapters have sections of possible remedies. Chapter 2 deals with the failure of the court to give equal access to Mr. Ongwen as a disabled person. In addition to being mentally ill, he was mentally disabled, right? He needed more time, he needed breaks, there are lots of things that he needed. They barely paid attention, or if they did, it was late. Let me give one example of that, and then I want to talk about sentencing and complementarity to finish off the presentation. One big example of the failure of the judges to treat Mr. Ongwen, the defendant, as a disabled person and give him full access was that when it came time at the end of the case, as those of you studying or practicing criminal law know, your client has to make a decision about whether he or she will testify, right? The client has the right to remain silent. That cannot be held against him or her. All right. Because Mr. Ongwen had been diagnosed with mental disorders and treated, not only by treated by the physicians, not our physicians, but treated by the medical physicians at the detention center from the very beginning, was on medication, right? This was no secret. Because of this, the position of counsel was, we want to know, is Mr. Ongwen healthy enough to make what's called an informed decision about whether or not to testify in his own behalf? Would he understand the consequences? Would he understand the risks? It's a decision not for me or my colleagues as counsel, but for Mr. Ongwen, right? Because he's the person doing the time if convicted. And we requested what's called a Rule 135 medical examination, in this case, a psychiatric examination. And we were denied this request. So we never could even broach the question with Mr. Ongwen because the court denied him his right to a medical examination in this case so that he could make a decision whether or not to testify. I don't know if that came out clearly, but the point is that the issue of disability, the medical examination, and bottom line, fair trial, and the right to testify or not and presenting a defense all came together in this, which was our third application for a medical examination. We kept getting shot down over the years. We needed it for other reasons. So that's an example. Now let me move on to the question on the last question that Professor Asala was talking about more. I think that there is a way in terms, for example, of sentencing to safeguard the rights of accused persons in a way that acknowledges his or her culture through the Rome Statute, which dictates the principles and guidelines of the International Criminal Court. The International Criminal Court, as many of you may know, is, quote, complementary, you can see in the preamble here, complementary to national criminal jurisdictions, which means that if a national criminal jurisdiction basically can deal with the matter or the legal matter at hand itself, deference is given to it and the person is not sent to the International Criminal Court. Now, there's a lot to this, and there's a lot of contention about this, about whether countries can or cannot and what they're going to do. But I think that it's basically that this is the principle. The principle has been enacted at the tribunal, certainly for Rwanda, and at the ICC, only in terms of complementarity in tracking suspects, right? The trackers or the law enforcement, get together to look for who's ever missing on the docket. But what I've argued here is, and others have argued, is that in determining the sentence, that there should be some way to incorporate the traditional justice systems through complementarity as well as through individual circumstances. You can check this later, but what I've argued here is that the article which determines the sentence and the rule should be amended to include traditional justice mechanisms in its process. Mr. Ongwen's case is the Acholi traditional justice system, but that's not true. I mean, there are many, many, many tribes. They each may have their own justice system. But the Acholi traditional justice system was directly and repeatedly rejected by the chamber. And also in determining the individual circumstances of the convicted person, Rule 145, right now, they include age, education, social, and economic condition of the person. That's Rule 145C. And I'm arguing that they also should include factors of race, culture, religion, and disability, because these are individual circumstances which may impact on determination of sentence. I'm not saying they have to, they must, they always will, but they have to be considered by the sentencing court, which was clearly not the case in Ongwen.
Thank you very much, Beth. I do agree with you entirely that there's need for the Rome Statute to incorporate cultural mechanisms. And perhaps it's for us to inform the journey on how to have these mechanisms incorporated to be complementary to the International Criminal Court. So thank you very much. This marks the end of our discussion. And perhaps there is a question for you in the comments. What is your personal position on the argument that international criminal law, especially through institutions like the ICC, has shown bias against African states and leaders?
I totally agree with that statement. There's no question in my mind. The example I gave about the defendants, there's absolutely no question in my mind. There's bias towards the defendants, the African defendants, who it's, as I think Rachel Lopez wrote an article. She talked about criminalizing blackness. I quote this in my book. I mean, to me that's absolutely true. And I think that it's so, and there are probably, many other ways this comes up. I mean, just recently, for example, I watched some of the Coney confirmation hearings yesterday. They were earlier this week, and the lead counsel is an attorney, probably a barrister, maybe he's QC, I don't know, from England, white male. Now, my question is, without having a comment on him, the registry has a list of hundreds of people, many of whom come from African countries. Why the registry appointed this person, is you can figure it out, right? But these are the kinds of issues that we, number of organizations, have objected to and continually fight around, because it's right there, right? And it's not just a question of, it's not simply a question of talking about it, and it's not a question of consciousness raising, none of this stuff. It's a question of changing and aggressively changing what the practice is, right? And making the practice fair. That's what we're talking about. It's clearly unfair. And that's what's happened. And I just want to say too, I didn't get a chance to, I mean, the ICC is built on, as I said, selective prosecution, right? The African countries were in the forefront in 97, 98 at the PrepComs before the Rome Statute in pushing for the ICC, right? It has become an African court, and I don't mean that in a positive sense, and it's a sense, an African court in the sense that only Africans become the focal point of the legal system, right? And now it'd be interesting to see what, if anything, happens with the effectuation of the arrest warrants, which are absolutely deserved for, for Gallant and Netanyahu, right? But, and also for Putin as well. I mean, the situations in Ukraine and Israel. But, the big powers, including, the US, there were I think there were 7 votes against the Rome Statute, including the US and Israel. And these countries have never let the world forget that they will fight to be out of the reach of the International Criminal Court. And lastly, I just want to say quickly, I say this cognizant that the International Criminal Court is being attacked. Certainly the leadership of that is my government under Trump and the sanctions. And I'm not, I don't support, obviously, I don't support the sanctions, all right? But for the International Criminal Court to fight back, it can't sit back and just say business as usual, right? It has to fix itself if it can. There are some people who criticize it and say, look, we got to get rid of the whole thing. It's too Western, it's too white, right? It's too culturally biased in favor of the West, right? And the whole project has to go, right? I don't know, that may be, my position, ask me next year, but I'm simply talking to somebody who's fought within the system to try to at least not just expose it, but to make it fair for my client, right? That was really the impetus. So that's constraints in which the book is written.
Okay. There is another question, Beth, for you. In your defense of Ongwen, how did you handle the legal and moral challenge of presenting someone who was both a child victim and later a military commander?
Okay. Our position, our position our position is once a victim, always a victim, right? That's what our expert evidence said. And it is true the prosecution case was Ongwen gets abducted at 8 or 9. He rises up through the ranks during a number of years. He also tried, I would add parenthetically, he tried to escape at least 5 times during that time. He was imprisoned. LRA has jails for its members. He was imprisoned in LRA jail for trying to get out, right? So we're not talking about somebody who sort of dealt with what was happening to him, without any kind of response. But look, I mean, I've never been abducted as a child soldier. I've listened to the testimony from the victims' witnesses, and I think that, and I've listened to our expert testimony. There's child soldiers, according to one of the victims' expert, Wessel said, they have a certain kind of resiliency, right, to survive, right? I don't agree with the prosecution theory that he rose up through the ranks, or technically there's some differences with factually what happened. But even if you adopt that theory, right, it's not like Mr. Ongwen has, quote, agency. I mean, these child soldiers were facing death. In the book, I talk about how Mr. Ongwen, after a few days of his abduction, he's 8 or 9, there were some other abductees who tried to escape. And as a lesson, the LRA pulls them back and forces Mr. Ongwen and his colleagues, other abductees, to pull out their intestines and put them around their neck, right? And eat food with the blood streaming down. He's described that in unsworn testimony at the sentencing. And you should take a look at these videos because he speaks best for himself. But we're not talking about a situation where, my view, contrary to the prosecution and judgment, that he was free to act on his own, right? It's child soldiers simply aren't, in my view. And I refer to the experts, and I'm not, I learned everything about child soldiers from the case. What can I say? I may not be the best expert, but that's our view. And victimhood never ends, right? I mean, people who've suffered trauma, doesn't matter what it is, trauma lives on. Lubanga case, right, which involved child soldiers, the expert, either for the court or prosecution, I don't remember which, Dr. Shoya, testified there are long-term effects. I mean, it's common sense. So that's how I would answer that question. And morality, morality, I'm not sure enters into it. I understand why the person may be asking that, but as our defense expert, Professor Avuga, said, whatever Ongwen learned at home, he goes into the LRA, and his book of morality was just shredded and thrown out by Coney. So I don't have any comments about, about morality. What can I say?
Yeah, thank you very much, Beth. And that question brings us to the end of our talk show today. And we wish you the very best.
Thank you so much. And also I would just want to say that let me just give my website in case people want more information about the case, or there's a way to contact me. It's Beth S. Lyons, BETHSLYONS at AOL.com.
Thank you, Beth. We look forward to more engagements in the future.
Thank you so much. And I want to thank everybody for listening, and thank you for the questions. And if you have more, plenty of information, plenty of stuff I can send you, and I'd be happy to do that. But please go to the website. And one last plea, I put on there videos from Mr. Ongwen's unsworn statements that he made at sentence hearing and also on appeal. He spoke for 30 minutes. I mean, as I said, I think that it's you make your own judgment about it, but I think it's important that in these cases, which, I mean, it's all his stuff is all over the internet. I know. I mean, people have gotten their PhDs, people are, someone made a movie about this stuff. I mean, it's all over the place, but you need to hear his own words before you make judgments on various issues. So I really encourage you, go to the videos. They're short, and take a look at what Mr. Ongwen says in those videos. So thank you very much.
Thank you. And thank you for all our viewers tonight. You're most welcome another time. Good night, everyone.
It's stopped.